Jose Rodriguez.
Thank you, Mr. Chairman, and my distinguished colleagues in this hearing of the Committee on Justice on the complaint of Mr. Edwin Cordevilla and Associate Justice of the Supreme Court, Margaret Leonen. Mr. Chairman, our rules clearly states that the allegations of the complaint should be true and correct of his personal knowledge, meaning the complainant, or based on authentic records, or based on authentic records. I have with me here the verification. I've been reading and rereading this complaint since it was referred to the committee. It says, I, Edwin M. Cordevilla, under oath state that I am the complainant in the above entitled verified complaint for impeachment, and I have caused the said complaint to be prepared and have read the contents thereof, and that the allegations therein are true and correct based on my personal knowledge. So this pertains to and would therefore be able to apply and being true to Section 3 of the statement that they should be true and correct of his personal knowledge. And the second one is quite not directly complying with the second requirement that it should be or based on authentic records, because after personal knowledge, the complainant states, and appreciation of the documents and other authentic records pertinent thereto. So that is the exact wording on the verification. Now, Mr. Chairman, as stated by confirmed by our committee secretary, none of these annexes to the complaint, upon question by the Honorable Deputy Minority Leader, none of this first is authentic, and none of these are certified, either originals or certified true copies. Because an authentic document can either be original or certified to as true copies by the proper custodian of the document or the one issuing the document. So therefore, on this particular point, it is clear that it is not based on authentic record as required by our rules. Because we see, Mr. Chairman, as we read the complaint, that all the annexes are all Xerox copies and mainly coming from newspaper reports, online reports. Prefatory statement is based on Annexes 1 and 2 coming from ManilaTimes.net, 1 and 2, both ManilaTimes.net, Xerox copies of these documents. Then we also have, for general allegations from 3 to 12, again, all online news accounts, Xerox, and attached to the complaint. From Inquirer.net, number 3 to 12, ManilaTimes.net, all of them are therefore, allegations are therefore Xerox copies of newspaper accounts. Then we go now to the meat of the issue, which are the articles of impeachment. There are 3, Mr. Chairman. The first one is a failure to disclose at least 37 cases within 24 months as mandated by the Constitution. And we see here in their submission on these annexes, from annexes 1.1a up to 1.32-5, Mr. Chairman, all are also newspaper accounts except 2, and these are Annex A and B, which are Supreme Court statistics on pending en banc judicial cases of respondent as of June 30, 2020. Again, as stated in one of the articles written by a columnist. There is no certified true copy, Mr. Chairman, of the Supreme Court report on the statistics on pending en banc judicial cases of respondent as of June 30, 2020. The other one, which is not a direct quote of newspaper accounts, is Annex B of Articles of Impeachment number 1, which is the list of cases assigned to Justice Mario Victor F. Leonen. Once again, this particular annex is also a reproduction of a listing of these cases in a newspaper account. Again, there is no authentic copy because there is no certification from the custodian of this list, which is the Supreme Court of the Philippines. In the second culpable violation of the Constitution allegation, delay in resolving cases before him as chairperson of the House of Representatives Electoral Tribunal. And we have from section 2.1-1 up to 2.14-3. Three supporting documents for the culpable violation allegation on a delay in resolving cases in the HRET. Well, again, of the three, two comes from ManilaBulletin.com. The other one is Rappler.com. There is this the website of the government Philippines HRET, the website of the HRET. Again, this came from the quotation in a comment in an article, which is likewise not authenticated by the House of Representatives Electoral Tribunal. So this is not also an authentic document. And then we go now to the third. Now this one is on betrayal of public trust. And the third article of impeachment, which is the betrayal of public trust, is failure to file his statement of assets, liabilities, and net worth, SALN, during his tenure at the University of the Philippines. And now once again, we have here also all our newspaper accounts or columns of commentaries, except that C, there is a communication operations of the Philippine Communications Operations Office. Again, there is no certified true copy of this. This is a Xerox copy. And then we have D, some statement of Justice Leonen, and then letters and so forth from the Supreme Court, and then bills of materials and so forth. Again, Mr. Chairman, no authentication, no certification from the proper custodian of these documents. So therefore, Mr. Chairman, this verified complaint on the second requirement of based on authentic records will not comply. However, Mr. Chairman, the word in our rule is or. So therefore, even if there is no authentic basic, that is not based on authentic records, it says or. So meaning the allegations are therein are true and correct of his personal knowledge. Now let us go into this, because on its face, we can see the complaint on whether it is really based on his true and correct, based on personal knowledge. That is the requirement, Mr. Chairman. This requirement is not hollow. It's not empty. This requires that upon on its face, it should be seen from the complaint itself that the allegations are really true and correct of the personal knowledge of the complainant. Mr. Chairman, a perusal of the complaint itself and the annexes would show that not one matter, not one annex is based on his personal knowledge. The records of the Supreme Court are in the Supreme Court. He's not a member of the Supreme Court, and neither can a member of the Supreme Court divulge under their confidentiality rule, because in the case of, for example, cases in the Supreme Court, the complaint violates the rules on disclosure and confidentiality of the Supreme Court. Its allegations, especially those relating to docket management and the case disposition issues involve matters that are part of court deliberations and are thus confidential and protected by deliberative process privilege, Mr. Chairman. So therefore, all the allegations of this delay in the case in the Supreme Court and the docket, that is very, very internal to the Supreme Court. And then also, the complaint does not state any justification or authority or applicable waiver to invoke matters privileged to the Supreme Court, which matters cannot be submitted as true and correct because precisely this is a privilege to the Supreme Court. So therefore, we say that on its face, in spite the verification statement that they are true and correct based on personal knowledge, Mr. Chairman, there is therefore it is not sufficient informed. It is not sufficiently verified. And its verification is a travesty because it says my own personal knowledge, and then what is being attached and being cited are newspaper online reports of columnists who wrote or reporters who wrote about these issues. And therefore, Mr. Chairman, the first requirement that it is true and correct based on personal knowledge will not obtain in this complaint. And therefore, the complaint, Mr. Chairman, is undeniably purely hearsay. And the rules of evidence would say that hearsay evidence would not stand in any proceeding. No matter what the optical presence of a verification, as we can see, stating in the verification, the complaint, the reality is that hearsay cannot be verified. Hearsay, all these newspaper reports, all this downloading of certain websites, all of this cannot be verified as true and correct under the terms of the verification of oath of the complainant. Therefore, what we see here as a consequence of the nature of being deemed being hearsay, the complaint is beyond verifying because they are all hearsay. All of the documents are hearsay. All the attachment annexes are hearsay. And so therefore the complaint is beyond verifying and should be deemed unverified. When form of which the verification is a part is appreciated as a deliberate facial feature of the complaint that serves a purpose of the highest order. The verification is written without regard to the purpose except to trivialize it, and the verification must be deemed not written. In view of the foregoing, Mr. Chairman, I would therefore maintain in this proceeding that the complaint is not sufficient in form. Thank you very much, Mr. Chairman.
Thank you for that, Comsec. Who is next on the line?
Next, Your Honor, is the Honorable Ed Salagman, Your
Honor. Earlier, the Honorable Lagman wrote this representation as chair, but since he is on Zoom, I request that the Honorable Lagman amplifies his manifestation verbally.
Thank you, Mr. Chairman.
Thank you.
And honorable members of this committee. I would like to confirm that earlier in the morning, I submitted to the Honorable Chairman and the members of the committee through the committee secretary of the Committee on Justice a 3-page position on why the instant impeachment complaint against Justice Mario Victor F. Leonen, filed by Mr. Edwin M. Cordovilla, is not sufficient both in form and substance. Mr. Chairman, honorable members, Section 3 of the House Rules of Procedure in impeachment proceedings provides that the complaint's verification should be based on complainant's quote personal knowledge unquote or authentic records quote unquote. Complainant's verification stated that his allegations are based on his personal knowledge and authentic records. However, a reading of the complaint readily reveals complainant's lack of personal knowledge respecting the preferred grounds of culpable violation of the Constitution and betrayal of public trust against Justice Leonen. In lieu of his personal knowledge, complainant vicariously relied on newspaper accounts and columnist opinions which are not authentic records and are invariably hearsay. Complainant failed to attach to his complaint the authentic records or official certifications on Justice Leonen's purported failures to seasonably decide cases and file his salience for a number of years prior to his appointment as Associate Justice. Verily, complainant's lack of personal knowledge and dismal failure to attach the pertinent official certifications or authentic records indubitably make his complaint insufficient in form. Liberality as to form may overlook these defects, but it must be recalled that in previous proceedings before the Honorable Committee on Justice, the then chairman of this committee announced that henceforth liberality will no longer be accorded in assessing sufficiency in form. The reason is that form is not a mere matter of formality, but it is an essential initial prerequisite to be satisfied by the complainant. In fact, it is the least requirement which a complainant must comply with. His default is fatal. With respect to insufficiency in substance, the complaint charges that Justice Leonen committed culpable violation of the Constitution and betrayal of public trust for failure to decide within 24 months around 37 cases assigned to him. Justice Leonen is accused of purportedly violating Section 15, Paragraph 1 of Article 8 of the Constitution, which provides that, quote, all cases or matters must be decided or resolved within 24 months from date of submission to the Supreme Court. The Supreme Court has categorically and consistently held that for Supreme Court justices and for the High Court itself, the subject constitutional provision is merely directory, not mandatory, because, quote, magistrates must be given discretion to defer the disposition of certain cases to make way for other equally important matters in the court's agenda. And as the court of last resort, the Supreme Court should be given ample amount of time to deliberate on cases pending before it. And I would refer to the cases of complaint affidavit of Elvira Enabes et al. Against former Chief Justice Leonardo de Castro, AM number 1811-09- Supreme Court. Marcelino versus Honorable Cruz Jr., GR number L42428, March 18, 1983, and Coscuruela versus Sandigan, GR number 191411, July 15, 2013. Mr. Chairman, distinguished members, verily, non-compliance with directory matters does not constitute an impeachable offense. Justice Leonen allegedly failed to submit his Allen according to the complaint for the years 1989 to 2003 and 2008 to 2009. Granting again that this is true, in that it cannot be a ground for impeachment for the following reasons. One, the alleged failure happened before Justice Leonen was appointed Associate Justice in 2012. An impeachable incumbent official should only be impeached for offenses committed during his incumbency. This would foreclose malevolent searches for bygone skeletons in distant closets. Moreover, Justice Leonen's qualifications and compliance with mandatory requirements have been vetted by the Judicial and Bar Council. Secondly, the offense of failure to file SAL-Ns prescribes after 8 years pursuant to Republic Act number 6713, incorporating the SAL-N law in relation to Republic Act number 3326 on prescription of offenses in spatial laws. This is doctrinal, Mr. Chairman, as held in Del Rosario versus People, DR number 199930, June 27, 2018, and Republic versus Cuanco Jr. et al., GR number 139930, June 26, 2012. The last year when Justice Leonen allegedly filed to file his SAL-M was 2009. The prosecution of which prescribed in 2017. Since impeachment proceedings are akin to criminal prosecution, then Justice Leonen cannot be impeached for an offense which has already prescribed or lapsed. Prescription both bars prosecution and impeachment. For the foregoing reasons, distinguished Chairman, I recommend that the impeachment complaint against Justice Leonen be dismissed for being insufficient in form as well as in substance. Thank you, Mr. Chair.
Thank you. Comsec.
Your Honor, next
Yeah.
is the Deputy Speaker, Senior Deputy Speaker Doyle Yachon.
Yes, yes, Mr. Chair. I'm to all the members of the House of Congress, to all our Filipino people, and of course, ladies and gentlemen, good morning. Our government today, this is a short manifestation only, Mr. Chair. Our government today is actually facing already a handful of issues, apart from the pandemic issue we have right now. And definitely all of these issues will definitely define the future or the political landscape of this country for few years to come. That's why today, as we face the grievous issue of impeachment vis-a-vis the pandemic issues that we have right now, I encourage everyone, every House member, to have the highest standards of discernment, to observe the highest standards of discernment in these cases. As we all know, impeachment cases, of all the cases that we have right now in the country, are the most celebrated ones. And celebrated as they are because these involve extreme cases of abuse of power, the extreme culpable breach of the Constitution, and these grounds have been lucidly stressed upon by the highest court in the cases of TS Bank versus Senate Impeachment Court, decided last February 9 of 2012. So with Gonzalez versus Office of the President, decided on January 28 in 2014, that considering the highest standards of discernment are being required because they deal with more than even heinous crimes, because it involves probably betrayal of public trust, then therefore we should deliberate on these issues with very much caution. But vis-a-vis about these issues that we have right now, we have also to consider the rules of procedure that we have right now. Number one, naalala ko po nung ako ay nag-aaral pa ng Bachelor of Laws, ako ay nagtatrabaho sa Supreme Court. Maliwanag ang sabi ng mga maestrado sa Korte Suprema na kaya sila naglalagay ng mga parameters o mga rules basically to avoid frivolous cases, to avoid delays, to avoid trivial issues that are even being elevated up to the Supreme Court. And in the same way, we have also cases and rules to be observed in the House of Representatives, particularly the rules of impeachment. It's very explicit and very categorical under Section 3, Paragraph 3 of the impeachment rules. It is clearly provided therein that the complainant in filing an impeachment complaint must be based on authentic records. Or if not, it should be out of his own personal knowledge. Now, browsing on the allegations of the complaint, I would like to understand, of course, the allegations of the complainant, as well as the manifestation of our good colleague from Locos. But seeing very clearly the allegations of the complaint or the impeachment complaint against Justice Leonen of the Supreme Court of the Philippines, the basic issues herein are actually not based on authentic records, because as clearly provided for and under the manifestation of our COMSEC, there are no authentic records on this matter. And more importantly and more significantly, I would like to stress upon this committee, Mr. Chair, that particularly the allegations as to the failure to dispose of the cases, as mentioned and alleged in the complaint, as well as the delay in the HRET cases, plus the non-filing of silence, are all based on article reports. I was part of the impeachment committees way back in the 16th Congress, 17th Congress, and now of the 18th Congress. And I would like to be reminded of those clear parameters set forth by the previous committees. And there is no reason to treat this case very differently. As the allegations are not based on authentic records, and as the allegations are not based on personal knowledge, but based on article reports based on Manila Times, it behooves actually the committee to deal this with the highest standards of ruling, that in this event, we should have no recourse but to treat this impeachment complaint as unsigned pleading. There being such, or being the case, this impeachment complaint, sad to state, is a mere scrap of paper. And considering that we have so many problems or pressing problems that we have right now, I think the better way to deal with this is to dismiss this impeachment complaint based on insufficiency as to form, based on Rule 3, Section 3, Paragraph 3 of the impeachment rules. There being the case and being the case, Mr. Chair, I would like to move for the dismissal of the impeachment complaint that we have right now based on insufficiency as to form. I so move, Mr. Chairman. Thank you.
I
I
second,
second the motion.
second the motion.
I second the motion.
Second the motion.
I second the motion.
Second.
Dali po.
Second.
Magsasalita pa po ang chair. I have not said my piece yet. Comsec, we will be voting on this. Wala na bang iba magsasalita, Comsec?
Kaya the Deputy Minority Leader Belmonte wishes to make a point of inquiry.
Okay. Yes, Your Honor.
Thank you very much, Mr. Chair. Excited na rin po ako mag-second kay Senior Deputy Speaker, pero I have to make this point of inquiry lang po, Mr. Speaker, kasi I think it's important. I remember during a previous impeachment case, the then majority leader, an eminent legal scholar, like the chairman himself, warned the then complainant, who was a colleague of ours, that since he had a signed verified complaint, but he had no actual personal knowledge of what he signed as a verified complaint, he was probably and possibly subject to perjury and even a probable ethics case because he was a member of the House, Mr. Chairman. My point of inquiry lang po is, again, hindi po malinaw yung nakuha kong kopya, Mr. Chairman. Verified po ba, or may signed verified complaint and subscribed and sworn to ng complainant, si Mr. Cordevilla, ang kanyang impeachment complaint? And kanino po to nakapirma? Ang records ko po ay sa mismong Secretary General ng House po siya nagpa-verify. And as such, pwede pong isang frivolous complaint na nag-verify siyang, nagsabi po siyang personal knowledge po niya, hindi po ba siya subject sa contempt proceedings din dito sa House dahil sa House po siya nag-verify na nagsabi po siyang...
Your Honor, we will treat that on other matters. Unahin mo lang natin itong point at issue.
Thank you, Mr. Chair.
Mr. Chairman.
Yes, Your Honor.
Mr. Chairman, I made a manifestation to give my manifestation also, if ever, and I'm ready to second the motion of Deputy Speaker Leonen, but may I be allowed to make a manifestation, Mr. Chairman?
Comsec, how many members do you still have after Honorable Abante?
Your Honor, the list is as follows. First is the Honorable Deputy Speaker Bienvenido Abante, then Deputy Minority Leader Carlos Zarate, and then Deputy Speaker Pablo John Garcia. Your Honor.
So we will be acting on that motion after all those who manifested their desire to speak on this issue must have said their piece. So may we now go to sino ba?
Deputy Speaker Abante, Your Honor.
Okay, Honorable Deputy Speaker Abante.
Thank you. Thank you, Mr. Chairman. I am not a lawyer, but I'm a very observant member of the House. And I'd like to make this observation, Mr. Chairman. The gravity of an impeachment complaint cannot be discounted. You can talk to any ordinary citizen in the street who do not even know the laws of impeachment. And he will tell you that any impeachment complaint is very serious and grave. Henceforth, anyone who files an impeachment complaint should not be done just because he does not like the person or he has a grudge to grind. How grave is an impeachment complaint, Mr. Chairman? Looking at the impeachable offenses like culpable violation of the Constitution, which means a deliberate and wrongful breach of the Constitution. But it also says, and I quote, violation of the Constitution made unintentionally, in good faith, and mere mistakes in the proper construction of the Constitution do not constitute an impeachable offense. We talk about betrayal of public trust, Mr. Chair, betrayal of public interest, inexcusable negligence of duty, tyrannical abuse of power, breach of official duty by malfeasance or misfeasance, cronyism, favoritism, etc., to the prejudice of public interest, and which tend to bring the office into disrepute. That's how grave any impeachment complaint is, Mr. Chair, as I observe. Citing the manifestation of Deputy Speaker Rufus Rodriguez, who is a very good lawyer, and even Congressman Lagman, like kababayan, questioning the substance of the complaint to be true and correct, and that of personal knowledge being taunted about as hearsay. The complainant is making a mockery of the law, and that this impeachment proceeding is an exercise in futility when we have more important things to do and bills to tackle. May I just, Mr. Chair, one by one, speak on the complaint itself. First of all, the complaint seems to suggest that Justice Leonen is anti-Duterte because he was appointed by former President Aquino. Are we supposed to impeach a justice of the Supreme Court because of his political beliefs or his affiliations or who appointed him? Is that what the Constitution states? Number two, in the complaint, there is also a charge that Justice Leonen should be impeached for failing to decide around 36 cases within the 24-month period. Seriously, is this a ground for impeachment under the Constitution? Number three, there is also a charge that Justice Leonen should be impeached because he arbitrarily delaying cases in the HRET. But the HRET is a collegial body composed of a mix of Supreme Court justices and congressmen. If there is any delay, that cannot be done by just one member. Should we also impeach the other Supreme Court justices who are members of the HRET? Should we also punish the congressmen who are members of the HRET for this delay in resolving election cases as alleged? Number four, the complainant also paints Justice Leonen as anti-Marcos. But the decision of the Supreme Court on the Marcos electoral protest for VP was decided with a unanimous vote. Should we also consider the other 14 justices who voted with Justice Leonen as anti-Marcos? Should we impeach all of them? Number five, the COVID pandemic is still raging in our country. People are dying every day, and we need all this the time we have in Congress to legislate measures that will help our people fight this disease and our country to recover. Do we really need an impeachment during a pandemic? Is this really the right time to do this? Mr. Chair, that's why I am fully supporting the dismissal of this impeachment complaint. Thank you very much.
Next is the Honorable Zarate.
Thank you, Mr. Chair. Magandang umaga po sa ating lahat. Once again, this committee, this House is called upon to address a very important issue, and our duty is now being invoked to rule on this impeachment complaint. to make our high officials accountable. I fully agree with the chair earlier when he said that an impeachment complaint should be treated as an extraordinary means to make our officials accountable. And thus, we have to use this with utmost care. And I certainly agree, Mr. Chair and Lord, the masterful and surgical dissection of our esteemed colleagues like Deputy Speaker Rufus Rodriguez and Representative Edsel Lagman, our legal luminaries in this committee and in this House, as they analyze the complaint both as to form and even as to substance. The 201-page complaint, Mr. Chair, I fully agree, did not only comply with our rules requirement that it should be based on personal knowledge or authentic records. In fact, I will hazard to say that if we further peruse the complaint, even as to substance, it also failed to comply with our requirements. Tama po yung sinabi ng ating mga kasamahan, Mr. Chair. No? Kung babalikan lang natin, yung rules ng ating verification talagang wala na ito, hindi napapasa. But, you know, I also read carefully this complaint and even the verification several times. And I observed that the complainant made some legal maneuvers. Not only that, he said that this is based on his personal knowledge, which we already said it is not. He conjoined this with saying that personal knowledge and appreciation of, if I may quote directly, Mr. Chair, appreciation of the documents and other authentic records pertinent thereto. So lumalabas po, Mr. Chair, no? He made, to probably cover up with the lack of personal knowledge, he made reference and incorporated his appreciation of the authentic records. And it even, that, I think, legal maneuver, that legal contortion, that language acrobatics even made his verification worse. So, Mr. Chair, it cannot hide or mask the bare fact that, again, this complaint, as filed by the complainant and as endorsed by our colleague, suffered fatally as to form and even as to substance. Lahat po ito ay based sa hearsay documents, based only on newspaper clippings. Kung sa layman pa po, ito po ay chismis lamang. And we cannot rely on chismis, no? On hearsay to impeach our high officials. The lack of knowledge of the complainant is apparent. And now he wants to use this committee, this House, to his foray into fishing expedition. Gagawin tayong fishing net to possibly justify the allegations he made in the complaint. Mr. Chair, at a time like this, when Congress should focus on more important matters like pandemic responses, pandemic interventions, when our people are still suffering from the grave crisis aggravated by this pandemic, more than 1 million people of our kababayans are already afflicted by this COVID-19. More than 20,000 were died of this COVID-19 disease. No? So we should focus our energies as a House, as a committee, on these pressing problems. Thus, I agree with our colleagues that at the first instance, and this is the first instance, we should not allow Congress to be weaponized, if I may say, once again, for the sake of some vested interest at the expense of the independence of the other branches of our government, especially the judiciary, which have been subjected to attacks in these past years. And certainly, if we will stop these attacks now, then mahihinto din natin, mapipigilan natin yung chilling effect that is now reverberating in the other agencies and the other branches of our government. So, for all this, Mr. Chair, I fully agree and I support And I second the motion earlier made by our Deputy Speaker that this complaint should be dismissed. It should be dismissed, not only as to form, but even as to substance. Thank you, Mr. Chair.
Comsec, meron pa ba?
Finally, Your Honor, we have Deputy Speaker Pablo John Garcia.
Okay. Deputy Speaker Garcia is recognized.
Thank you, Mr. Chair. I agree with the previous manifestations, Mr. Chair, that we should dismiss the impeachment complaint against Supreme Court Associate Justice Mario Victor F. Leonen. Even if we were to grant liberality on the issue of form, Mr. Chairman, we should dismiss for lack of substance. This complaint is a truth based on two alleged offenses, which according to the complainant constitute culpable violation of the Constitution. First, respondent's actions and or failure to act on cases assigned to him as Supreme Court Associate Justice and as Chairman of the House of Representatives Electoral Tribunal. And two, his failure to file statements of assets, liabilities, and net worths, LNs, covering several years as lecturer, professor, and official of the University of the Philippines. On the first alleged offense, I must reiterate my consistent position before this committee, first expressed during the 15th Congress in the impeachment proceedings against Ombudsman Merceditas Gutierrez and Chief Justice Renato Corona, that I do not believe that the justice's actions in cases before him should be made a ground for his impeachment. Firstly, we are not privy to all the facts and circumstances, the evidence and the deliberations surrounding each case, and therefore would not be in a position to judge a justice's actions or perceived failure to act in a case. Our judgments on a justice's actions, especially in a deliberative body, would inescapably border on conjecture and speculation on whether we agree with a decision or action or failure to act or not. Secondly, and more importantly, impeaching a justice on the basis of his actions and inaction on cases before him would amount to a review by this political branch of the decisions of the judicial branch. This certainly was not the intent of the framers of the Constitution, and most certainly was the reason why impeachment cases are limited to culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. In my opinion, the ground for impeachment should be extraneous to a justice's official decision, opinion, or disposition of a matter before him. On the second alleged offense, I must state that even if we were to assume that these were true, they were committed way before respondent assumed the office for which he is being impeached now, that is, as Associate Justice of the Supreme Court. It is my view that impeachment should be limited to offenses committed during the incumbent's tenure and not any time before it. This is not to say that if this allegation is true, respondent should be exempt from accountability for failure to file SALN. As in the case against former Chief Justice Maria Lourdes Sereno cited in the complaint, the failure to file SALNs may be evidence of lack of integrity. But that was dealt with not in an impeachment proceedings before this Congress, but in a quo warranto case before the Supreme Court. I therefore second the motion of the Senior Deputy Speaker to dismiss the complaint, not only in form, but also on substance, Mr. Chairman. Thank you very much.
Thank you. Nothing more? Comsec? Akin na ba?
That's all, Your Honor. Yes, sir.
Okay. Let me start as a preface. My reading section 28 of the Rules of Court, the Rules on Evidence. The rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as hereinafter provided. Ulitin ko po, the rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as hereinafter provided. Wala kong nakita sa exceptions dito. This is the footstool of the hearsay rule. The impeachment complaint cites three grounds. Ground number one says the respondent committed culpable violation of the Constitution for failing to dispose of at least 37 cases within 34 months as mandated by Section 15, Paragraph 1, Article 8 in relation to Section 16, Article 3 of the Constitution, which mandates the prompt action and speedy disposition of cases. In support of that ground, the complaint alleges in paragraph 1.2 it says, in a newspaper article published by the Manila Times, it was reported that the 82 pending cases of respondent, 37 of these were assigned to him several years ago. Basis in a newspaper article. As long as our impeachment rules provides in Section 17, Article 7, that itong binasa kong Section 28, Rule 130 has been adopted as part of our rules. Hindi ko po matatanggap ang paragraph 1.2 in support of the first ground dahil it was based on a newspaper article. 1.3 reads, records from the Supreme Court reveal that as of 30 June 2020, respondent had 37 quote aging unquote cases. A copy of the Supreme Court report is attached here to as Annex A. But a quick look of it, as earlier clarified by the committee secretary, hindi po ito authentic copy. It cannot therefore be accepted by this committee as an allegation in support of the first ground. Also, 1.5, from paragraphs 1.5 up to 1.32, that is from pages 15 to page 24 of the complaint, all these allegations are not based on personal knowledge, much less supported by authentic pertinent records. Ground number one in the impeachment complaint must therefore fall. Let's go to ground number two. The complainant alleges a second ground for impeachment that the respondent committed culpable violation of the Constitution for arbitrarily delaying the resolution of cases pending before him as chairperson of the House of Representatives Electoral Tribunal. It's read for brevity. 2.1 alleges, and that is in page 25. Paragraph 2.1 alleges that in October 2019, respondent was appointed as the chairperson of the HRET when he headed the tribunal. There were 34 election cases filed, consisting of 21 electoral protest cases and 13 co-warranto cases. Wala pong authentic record supporting this. Now, 2.2 alleges, with respondent at the helm, the election cases moved at a snail pace. In fact, almost a year later, ako, Picot Party List Representative Alfredo A. Garbin Jr. revealed that there were still more than 30 pending cases electoral protest cases pending before the HRET. What has respondent been doing about this? The complainant based his allegation on what he heard from Representative Alfredo A. Garbin Jr. Even if we have to assume arguendo that this is correct, this is, however, hearsay. Again, judging from what I earlier read, Rule 130, Section 28 of the Rules of Court, which has been adopted suppletorily by our rules on impeachment. Going now to ground number 3. Ground number 3 says, the respondent committed betrayal of public trust when he failed to file his statements of assets, liabilities, and net worth during his tenure at the University of the Philippines as mandated by Section 17, Article 11 of the 1987 Constitution. This also negates the probity and integrity required of him as a member of the judiciary. Now, paragraph 3.5, this is at page 31, reads 3.5. Based on a published article, respondent only filed his salience for the years 2004, 2005, 2006, 2007, 2010, and 2011. Thus, for the years 1989 to 2003 and 2008 to 2009, a total of 15 years, respondent completely ignored the law. Now, again, what was the basis for this? The basis is a published article citing columnist Roberto Tiglao, and this is in 3.6, 3.7, and onwards. Again, being hearsay and not based on authentic record, we cannot take this as a ground even on the question of verification on the matter of form. In fact, all other paragraphs from 3.1, page 29, up to paragraph 3.36, that is page 39, no personal knowledge has been alluded to, no authentic record has been referred to in those allegations. Cited allegations at best are admissions of a third party, not a respondent. Yet again, Rule 130, Section 28 of the Rules of Court provides, quote, the rights of a party cannot be prejudiced by an act, declaration, or omission of another. With Rule 7, Section 17 of our impeachment rules, mandating that the rules of court shall, as far as practicable, apply impeachment proceedings before the House, quote unquote, and considering, moreover, that Rule 16, Section 1 of the same supplementary rules of court provides that a motion to dismiss can be made on any of the following grounds, particularly paragraph J, that a condition precedent for the filing of the claim, or in this case of a complaint, has not been complied with. The chair opines that what we have in sum is an unsigned, quote, unsigned impeachment complaint that is provided for in Section 3, third paragraph, due to the failure of the complainant to verify his complaint on the basis of allegations therein, quote, allegations therein that are true and correct, of his personal knowledge or based on authentic records, unquote. Ulitin ko po, The verification failed to satisfy the requirement that the allegations of complainant must be based on his personal knowledge or must be based on authentic records. The chair would like, as I earlier point out, to emphasize that while under Section 3, third paragraph, Rule 2, upon a finding of insufficiency in form, we are to refer the complaint back to the Secretary General. There is, however, an alternative, and I cited Rule 16, Section 1, Paragraph J, that we can dismiss this complaint outright due to the failure of complainant to comply with a condition precedent for the filing of this complaint. The complaint, ulitin ko po, tantamounts to an unsigned impeachment complaint, as so stated in Section 3, third paragraph of our impeachment rules. So, the chair now is open to any motion. Alin ang gagawin natin? Should we throw this back to the SecGen or should we dismiss this outright? Any motion?
I move, Mr. Chair, to dismiss outright the complaint.
Mr. Chair?
Yes, Your Honor.
Yeah, the incident pending before this committee is a pending motion to dismiss the complaint based on Section 3, Paragraph 3 of the impeachment rules. The impeachment complaint is insufficient as a substance, and there being a motion that is pending, and so move. May I therefore request, Mr. Chair, your kind intercession to make the necessary ruling. Thank you, Mr. Chair.
Comsec, the first motion is should be to outrightly dismiss this on the basis of Section 1, Rule 16 of the Rules of Court that has been adopted as part of our rules pursuant to Section 17, Rule 7 of our impeachment rules. If that is carried, then we will no longer return this back to the SecGen, but rather we will be preparing and submitting a committee report on the matter.
I so move, Mr. Chairman.
So,
I second.
Second.
Mr. Chair.
Second.
Comsec, will you take a vote on that?
Yes. Yes, Your Honor. Thank you. So the pending motion, Your Honor, is the motion to dismiss the impeachment complaint filed by Mr. Edwin Cordevilla against Supreme Court Associate Justice Marvin Leonen. A vote of yes is a vote to dismiss the complaint, while a vote of no is a vote to sustain the complaint or not to dismiss the complaint. We start with the regular members of the Committee on Justice. The Honorable Vice Chairperson, Cyril Beng Abueg Zaldivar.
Mr. Chair, my vote is yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Vice Chairperson, Nayala Rose Bainto Aguinaldo.
Mr. Chair, my vote is yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Vice Chair, Jonathan Keith Flores. Proceed with the Honorable Vice Chair, Juan Fidel Felipe Nograles. We proceed with the Honorable Vice Chair, Alfredo Garbin Jr. The Honorable Vice Chair, Ramon Nolasco Jr. The Honorable Representatives Ruel Peter Gonzaga. Honorable Representative Doy Liachon.
I vote to dismiss the complaint.
Honorable Cheryl De Loso Montalia. Honorable Tyrone Agabas, Honorable Peter John Calderon, Honorable Dalia Loyola, Honorable Manuel Luis Lopez, Honorable Corazon Nunez Malanyaan, Honorable Joseph Ramirez Sato,
I vote yes to dismiss.
Honorable Aleta Suarez, Honorable Hector Sanchez, Honorable Edsel Lagman,
Mr. Chairman, I vote yes to dismiss the impeachment complaint against Justice Leonen
the Honorable Eric Goyap,
due to insufficiency in form without prejudice to returning a copy of the complaint to the Secretary General pursuant to our rules.
the Honorable Eric Goyap, the Honorable Arlene Brosas,
My vote is yes to dismiss at the first instance the complaint, Mr. Chair.
the Honorable Sergio Dagook,
Yes for the outright dismissal, Mr. Chair.
and the Honorable Maria Victoria Umali. We now proceed with the ex officio members, the Honorable Speaker, Lord Alan Velasco, Honorable Deputy Speaker, Ferdinand Hernandez,
I vote yes to dismiss the complaint.
the Honorable Deputy Speaker, Evelina Escudero,
I vote yes to dismiss the case, Mr. Chair.
Honorable Deputy Speaker, Lauren Legarda, Honorable Conrado Estrella III, Honorable Prospero Pichay Jr., Honorable Roberto Puno, Honorable Brother Eddie Villanueva, Your Honor, we have received a message from the Honorable Arnold Oteve in favor of dismissing the complaint.
Check may mga interferences.
May we request everyone who is not on to please mute. Thank you. The Honorable Deputy Speaker, Juan Pablo Rimpi Bondoc. The Honorable Deputy Speaker, Eric Martinez. The Honorable Deputy Speaker, Bernadette Herrera D. Christine
My
Pinto.
vote is yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Deputy Speaker, Christine Singson Miham.
My vote's yes for outright dismissal.
The Honorable Divina Grace Yu. Honorable Rogelio Pacquiao. Honorable Wesley Gatchalian.
I vote yes, Mr. Chair.
Honorable Bienvenido Abante Jr.
I vote yes.
Honorable Michael Romero.
I vote yes to dismiss the petition for lack of form and substance.
The Honorable Thank you, Your Honor. The Honorable Camille Villar. The Honorable Neftali Gonzalez II. We received a yes vote in favor of dismissal from the Honorable Gonzalez. Honorable Deputy Speaker, Jose Atienza Jr.
I vote yes to dismiss on the basis of the brilliant presentation of Rufus Rodriguez, a very brilliant lawyer. Yes to dismiss.
Thank you, Your Honor. The Honorable Deputy Speaker, Rosemary Arenas.
I vote yes to dismiss the case, Your Honor.
Thank you, Your Honor. The Honorable Deputy Speaker, Rodante Marcoleta.
Yes, Mr. Chair.
The Honorable Deputy Speaker, Henry Waminal. Honorable Deputy Speaker, Pablo John Garcia.
I vote yes to dismiss the complaint, Mr. Chair.
Thank you, Your Honor. The Honorable De Gracias Victor D.B. Sabellano.
I vote yes to dismiss the complaint.
Your Honor, the Honorable Vilma Santos Recto, Honorable Deputy Speaker Mujib Hataman,
Yes for the dismissal.
Honorable Deputy Speaker Rufus Rodriguez,
Chairman, before I vote, may I just thank Deputy Speaker Nico Atienza for his kind words. Mr. Chairman, I now vote yes for the dismissal of the complaint of Mr. Edwin Cordevilla for being insufficient in form, without prejudice to the return of such complaint to the Secretary General within 3 session days with a written explanation of the insufficiency under Section 4 of Rule 2 of the Rules of Impeachment of the House of Representatives at 18th Congress. Thank you, Mr. Chairman.
thank you, Your Honor. Proceed with the Honorable Deputy Speaker, Strike Revilla.
Mr. Chairman, I vote yes to dismiss the case. Thank you.
Thank you, Your Honor. The Honorable Deputy Speaker, Abraham Bambol Tolentino. The Honorable Deputy Speaker, Isidro Ungab.
I vote yes, Mr. Chairman.
Thank you, Your Honor. And the Honorable Deputy Speaker, Marlene Alonte.
I vote yes, Mr. Chair.
Thank you, Your Honor. The Honorable Majority Leader, Ferdinand Martin Romualdez.
I vote yes.
Thank you, Your Honor. The Honorable Senior Deputy Majority Leader, Jesus Crispin Remulla. The Honorable Deputy Majority Leaders, Juan Miguel Macapagal Arroyo.
I vote yes, Your Honor.
Thank you, Your Honor. The Honorable Deputy Majority Leaders, Leanda Bolilla.
I vote yes to dismiss the complaint, Mr. Chair.
Thank you. The Honorable Crystal Bagachin.
I vote yes to dismiss the complaint, Mr. Chair.
Thank you, Your Honor. Honorable Christopher De Venecia. Honorable Jesus Bong Suntay. Honorable Tyrone Agabas. Honorable Xavier Jesus Romualdo.
Voting yes.
Mr. Chair. Mr. Chair.
Yes, Your Honor.
Yeah, my name was called. I believe I was on mute. So I vote yes to dismiss the complaint based on insufficiency of form.
Thank you, Your Honor. The Honorable...
Yes to dismiss the complaint.
Thank you, Your Honor. We proceed now to the Deputy Majority Leader, Honorable Josephine Veronique Lacson-Well. We proceed with the Honorable Lawrence Defensor.
I vote yes to dismiss the complaint.
Thank you, Your Honor. The Honorable Maria Teresa Collantes. The Honorable Via Cristina Fariñas. The Honorable John Martin Yul Cervonieto.
I vote yes to dismiss the case.
And the Honorable Deputy Majority Leader Roger Mercado. We note the vote of yes from the Honorable Deputy Majority Leader Josephine Lacson-Well. We now proceed to the minority members. The Honorable Minority Leader Joseph Stephen Caraps Paduano. The Honorable Janet Guerin, Senior Deputy Minority Leader. And the Honorable Minority Leaders Jose Christopher Belmonte.
Chair, I vote yes to dismiss the complaint.
The Honorable Carlos Isagani Zarate.
Sir Chair, I vote for the outright dismissal of the impeachment complaint against Associate Justice Marvic Leonen.
The Honorable Sherry Antan. The Honorable Bayani F. Fernando. The Honorable Argel Joseph Kabatbat.
Mr. Chairman, May I know how my vote is recorded, Mr. Chairman?
Comsec?
Your Honor, we haven't received a vote yet from the Honorable Deputy Majority Leader Roger Mercado.
My vote is, thank you, Mr. Chairman. My vote is,
I'm sorry, Your Honor, it's a vote of yes for dismissal.
Honorable Mercado? Nag-freeze.
my internet connection is unstable, Chairman, but
What is your vote?
my vote is yes for dismissal.
Okay. Comsec?
Yes. Noted, Your Honor. And finally, the Honorable Chairperson of the Committee on Accounts, the Honorable Paulo Duterte. Your Honor,
my vote is yes for dismissal, Mr. Chairman.
Deputy Speaker Hernandez, nandiyan na ba?
Yes, sir. Nandito na po.
Okay.
Your Honor, Your Honor, the tally of the votes on the motion to dismiss the impeachment complaint is 37 votes in favor to dismiss the complaint, 0 votes against, and 0 abstention.
When you say 0 abstention among those who attended, because
yes,
we
Your Honor.
had 2 abstentions already from the proceeding. Okay, that being the case, comply Comsec with Section 4, Rule 3, that we have to return the complaint to the Secretary General within 3 session days with our explanation, not only on insufficiency, but on the fact that we had to dismiss the complaint based on Section 1, Rule 16 of the Rules of Court, which was adopted suppletorily by Rule 7, Section 17 of our impeachment rules. Okay?
Yes, Your Honor.
Any other matter? Yes, Your Honor.
Mr. Chairman, the impeachment complaint has already been dismissed. I earlier inhibited from participating in the proceedings, but since this has been dismissed already, Mr. Chair, I may already make some manifestation. Mr. Chair, this is one lesson learned for the committee. This is a complaint that has been filed before us and referred to us. And very clearly, with that voting of 37-0, there is a finding of a very clear lack of sufficiency in substance and form. And I think, Mr. Chairman, in order to prevent complaints like this in the future, the committee has to act on things like this by probably imposing sanctions or declaring certain complainants in contempt for making a mockery of the rules of the committee. And I think, Mr. Chairman, as another matter, this is something that the committee should deliberate on and discuss to send a signal to all those out there who may want to introduce impeachment proceedings to respect our rules, and not make a mockery of our proceedings. Thank you, Mr. Chair.
Noted, Comsec. Any motion to adjourn?
Move to adjourn, Mr. Chairman.
Second the motion.
Second.
Chairman.
Having been moved and duly seconded, the meeting is adjourned.
Thank you. Salamat.
Maraming salamat.
Thank you, Mr. Chair.
Salamat po, Chair.
Mr. Chair, thank you everybody.
Congratulations, Chairman.
Thank you po.
Maraming salamat po.
Salamat, salamat. Congratulations.
To all of us, nag-aaral tayo lahat. Lalo na
Congrats, Mr. Chair, to everyone.
Congrats, Mr. Chair.
Congratulations. Baby.